We would like to welcome our viewers once more from the United States and Canada, from Europe and the Middle East, and of course, in Armenia and Artsakh. There is a lot on the table. In fact, there are a lot of things that hang in the balance today, a lot of moving parts that will have tremendous consequences for the future of the Armenian Republic, for Artsakh, and indeed for Armenian people across the world. We are in tectonic times, and the aftershocks seem only to continue. We'll be digging into many of these crucial, pressing issues with you over the coming weeks and months. There is so much to study, to understand, and to analyze together. There are also moments of clear achievement, clear successes upon which we can build. And much of those successes have been in the legal sphere, and for good reason. If there's any place where justice and reasoning should prevail, probably should be in the courts. Today, we'll be discussing one of those important achievements with colleagues who were, frankly, the architects of one of the most important cases in the history of the Armenian Republic. We'll be discussing the successes reached at the International Court of Justice in the recent December 7th decision in the case of Armenia versus Azerbaijan. And with that, I'd like to kick it over to Garo to introduce our guests for this evening.
Thank you, Karnik. Good evening, everyone in the United States. Good morning in Armenia and Artsakh, and good day elsewhere. First, let me start, Karnik, by thanking our guests, as well as you, thanking Yeri Shagiragosyan, Levon Gevorkian, Karnik Kerkonian, and all of the rest of the team members led by Yeri Shagiragosyan, who went into The Hague and stood tall, spoke loudly and clearly, and advocated on behalf of the Armenian rights, Armenian cause, Armenian nation, and Armenian people. I want to thank you for your service, and I want to welcome you again on front lines. Yeri Shagiragosyan is one of our two guests at the moment. He is the representative of the Republic of Armenia before the European Court of Human Rights and the agent of the Republic of Armenia in the International Court of Justice. You might say he is the representative of Armenia in all international legal matters. By way of background, Yeri Shagiragosyan has studied at the Stanford Program of International Legal Studies, has a Master's of Law in International Legal Studies from Georgetown University, has studied at Yerevan State University, and we're going to hear so much about him that I don't want to spend these moments, precious moments, telling you what I think about Yerishe. Needless to say, I'm very fond of Yerishe. Levon Gevorkian is another fine fellow legal scholar that I'm very fond of. He is the chief legal officer at Digitain Armenia, also a member of the legal team that accompanied Yeri Shagiragosyan to The Hague just earlier this month. And he is the former head of law practice at EY Armenia, former managing partner at Legalata law firm, former lecturer at Yerevan State University, and former senior associate at Harutunian and Partners law firm. And last but not least, he's also a former foreign legal specialist intern at Public International Law and Policy Group. These are our fine guests this evening here live from Los Angeles for me, for you, Karnik, from Chicago. Take it over. Thank you. Welcome.
Thank you, Garo. If I may, I want to just jump right into the substance of the case and really kind of the procedural posture. And Yerishe, I'd like to start with you. I think that people really need to kind of understand not only the substance of the case, but where the case is in the stage of the proceeding. So if you would, could you tell us a little bit about the treaty that's involved in the case, as well as what exactly happened on December 7th with respect to the procedure? We've heard the phrase preliminary measures, and this was an indication for a request of preliminary measures. If you would, can you tell us a little bit about the procedural structure of the case at this stage?
Thank you, Karnik, and thank you, Garo, for introduction. It's a pleasure to appear on this platform again with you guys, and thanks for doing this initiative. I think it's very important to spread the word across the diaspora and Armenia and Artsakh. It's very important to discuss topics and issues that are relevant for Armenians, for all Armenians, and this is, I think, one of them. And of course, what happened on the 7th is it was the day of the reading of the orders by the International Court of Justice regarding the case brought by Armenia first against Azerbaijan based on the Convention on the Elimination of All Forms of Racial Discrimination. And also a mirror case brought by Azerbaijan against Armenia based on the same convention. The International Court of Justice issued the orders based on the hearings that took place back in October 2021. And during those hearings, 2 hearings back in back. First hearing was on the request of the Armenia to indicate provisional measures to Azerbaijan to secure certain rights guaranteed under the CERD. CERD is the abbreviation for the convention. Again, a mirroring request by Azerbaijan to indicate provisional measures to Armenia with regard to some measures that Azerbaijan thinks were within the scopes of the CERD, which was not true, as we saw when the orders came out on the 7th of December. And what happened actually, first of all, Armenia applied to the court and back in September, on September 16th, by filing an application on instituting proceedings based on the Convention on the Elimination of All Forms of Racial Discrimination. That's Article 22 of the Convention. And along with the application on instituting proceedings, Armenia also filed a request for indicating provisional measures to secure the guarantee the rights protected by that convention, pending the determination of the case on merits. So this is what happened. Actually, we asked the court to take measures, to adopt measures to secure the interest protected by the right, considering that there are plausible rights protected under the convention, and there is also a need, an urgency for the court to act to secure certain rights guaranteed under the convention and to prevent any harm that will be caused by the actions of the respondent government to the values protected under those rights, which actually it happened so that the court, I think, granted most of the requested measures by the Republic of Armenia. And of course, at this stage, we're waiting for the court to set some procedural timeline, which will happen in a month or so. And this is just the start of the beginning of the procedural, the procedure at the court. And so we will still have the opportunity to present more detailed written memorials to the court, substantiating the claims of the Republic of Armenia against Azerbaijan, providing necessary evidentiary materials, which is, of course, at this point, we're now working very closely on that with our team of counsels and experts. And depending on what written replies or what written memorials we're getting in response or from the other party, we'll have certain procedural structure of the case, meaning that whether we're going to have preliminary objections stage of the case, or or not. So that's the question. So in any case, this is the procedural setting that we are now at. We can go into substance if you want now.
I want to ask very quickly, would you say that the decision in the ICJ, and we don't want to get into the 14-1 versus 13-2. Would you say they were overwhelmingly in Armenia's favor or not?
They were certainly overwhelmingly in Armenia's favor. I think what Armenia asked for, I think we got most of the measures requested. And of course, one of the very hotly debated topics is the repatriation or release of the POWs and other captives, which the court didn't grant as a measure. But there is a reason for that, actually. Of course, this case, we should not forget that this is a case about the elimination of racial discrimination, and which is the central element and core of the case. Why Armenia brought such a claim against Azerbaijan? Very simple, because Azerbaijan has been engaging in very structured, very focused anti-Armenian hate propaganda policies inside the country, and which can be revealed like in many forms, including like internal policies or in educational materials, hate speech, public hate speech by high-ranking officials on a daily basis. Not only that, but also very structured policy internally to create this atmosphere of hatred and animosity, which is the #1 precondition for violating the peace or for war, for aggression. And of course, that's the core why Armenia brought such a claim. And of course, when bringing such claim and considering the environment that we are currently, we have POWs, of Armenian origin, ethnicity, and we could not to include this request in this legal proceedings. There was a possibility of getting a measure from the court. Of course, we substantiated. I think one of our counsels who was pleading before the court during the provisional measure hearing, I think made a very convincing case, a very sound case why the court should have ordered repatriation. But still, we have to understand that we were anticipating such development. We anticipating that this could be the case. But still, having said that, I don't think that the measure granted by the court in that respect, I mean, securing the rights of the POWs and captives, not repatriating, but also considering that it's plausible and there is also a risk existing. There is also the urgency existing there, and also connected with the treatment of the POWs, which the court considers that there is also a risk that this treatment is motivated by the national or ethnic origin of the POWs, meaning that because they are Armenians. And it also connected with if you read the order, it is very tightly connected with the propaganda of hate speech and animosity by high-ranking officials, which creates an environment in which the risk of bodily injury or psychological harm to the persons of Armenian origin being kept by Azerbaijan is becoming really high. I think that's a very strict logic there, and I think what we got in respect of the protection of POWs, I think it is really a victory at this point. That's what I say. We can go into the other measures granted, but this is one of the key ones that I wanted to just quickly focus on. Yeah.
So Yegise, the three of you, 1, 2, 3, are international lawyers. The three of you were at The Hague. I was not. I was following you. And I came away thinking, okay, this court acknowledged the mistreatment of the hostages. This court ordered Azerbaijan to follow the convention and its other obligations in terms of treatment of the POWs. But the court, to me, and maybe you can correct me. I understood it to have a limited instruments available at its disposal as a world court, if you will, to order the return of the POWs. Am I mistaken about that? And the question, and I'll throw it to my co-host Carnegie, and the three of you can tell me what's with that.
If I can quickly just comment, and then maybe colleagues will take it over, take it from there. Just if you look at the, wording in the court's order relating to the repatriation. First of all, it is very important not to forget the jurisdictional basis of the court. That's a very important starting point. The jurisdictional basis of the court's the proceedings is the Article 22 of the CERD, meaning that the court is very limited in determining or in applying only the Convention on Elimination of All Forms of Racial Discrimination, which sets certain boundaries, certain core, and regulates certain rights or provides certain rights and guarantees to them. And of course, the courts makes it very clear that when turning to the repatriation issue, that the repatriation of POWs and other captives or civilian captives is regulated by international humanitarian law, which is currently outside the scope of the jurisdictional basis of the court, and the court cannot directly apply the IHL conventions, meaning, for example, Geneva Conventions, which require repatriation of the POWs and civilian captives after the end of the hostilities. At the same time, the court's making some distinction between the detaining or keeping the POWs, not repatriating them, and the treatment of POWs. The court finds that the national ethnic origin is the motive for the treatment, but not motive for keeping the POWs detained. So this is the distinction where the court finds it. And I think we have to be mindful of this. And I think it's very understandable that why the court orders so. I think I'll stop here. Maybe colleagues will take it from here. Thanks.
If I may, I want to kind of reach out to Levon to really give us the contours of some of the other crucial elements of the court's order that relate directly to what Yerisha was just talking about in terms of court drawing that nuance, the issue of the national origin as the source of the intent, if you will, of the acts of the state vis-a-vis Armenian cultural heritage. If you could take us through the other pillars of the court order, I think that would really be useful.
Sure, Garnik. And prior to dwelling into that, there are probably two very important points that the listeners and the general public need to understand. Well, first of all, these are the provisional measures. This is not the final judgment. The final judgment is going to take years. Probably it's going to come like 5 or 6 years from now. So that's the first thing. So
I didn't hear that. The final judgment is going to take what? There was a disconnect.
It's going to take probably 5 or 6 years.
Okay.
So this is just a provisional measure. That is something that Armenians, both in Armenia and diaspora, need to understand. Mm-hmm. The second thing is that the case is not only about the outcomes of the war. The case basically covers, Armenia's claim covers decades of anti-Armenian discrimination directed against Armenians by the Azerbaijani state. So the provisional measures may be related particularly to the outcomes of the war, but that's not what the case is only about. The case is much, much bigger than the outcomes of the war. Now, coming to Garnik's question, and this is also very important to understand, is that we can basically divide Armenia's requests for provisional measures into 4 groups. The first group pertains to and I apologize for my voice because I just rehabilitated from sickness and I cough from time to time, but I'll try to be as smooth as possible. So the first group of provisional measures pertain to the POWs and captives. Mm-hmm. And that's not just the claim for the return, but that's also the provisional measure for humane treatment. The second group of provisional measures pertain to propagation of racist hatred, and that pertains to both hate speech and the so-called Victory Park, which was opened in Baku. The third group of provisional measures pertain to protection of cultural heritage. And finally, the fourth group are of general nature. That is provision like protection of evidence, refraining from acts which exacerbate and make the conflict more complicated, etc., etc. So what is important to keep in mind is that there is one provisional measure pertaining to each group that the International Court of Justice satisfied. So basically, the Republic of Armenia went to the court with 4 protected, let's say, groups, subject matters. And there is a provisional measure pertaining to each that has been satisfied. For the captives and for the prisoners of war, we have a provisional measure order for Azerbaijan to ensure that those individuals are treated humanely. For cultural heritage, we have a provisional measure ordering Azerbaijan to refrain from acts, to refrain from destruction of the cultural heritage and to prevent and punish individuals who are engaged in such practices. For hate speech, we have a very clear provisional measure indicating that Azerbaijan has to refrain at the state level from engaging in hate speech, and there is pretty much an acknowledgement there in the provisional measure order itself that Azerbaijan has been engaged in propagation of hate speech on the highest possible level. And of course, there is one provisional measure which is of a general nature and which is directed to both Armenia and Azerbaijan, saying that both parties should refrain from acts which would further exacerbate the conflict. So there is a huge distinction between the orders that the International Court of Justice granted against Azerbaijan and those that the International Court of Justice granted against Armenia. If you look against the 2 orders which were granted against Armenia, you'd very quickly realize that those are simply confirmations or reaffirmations of the obligations which otherwise already exist under the convention. So pretty much there is only one provisional order which is not of a general nature that is directed against Armenia, and it says that Armenia should punish and prevent individuals who are engaged in hate speech. There is absolutely no acknowledgement that Armenia has engaged in hate speech on state level. There is absolutely no acknowledgement that any of the private organizations that operate on the territory of Armenia and have been invoked in the Azerbaijani application have been engaged in such hate speech. There is simply a reaffirmation of the obligation which otherwise exists under the convention.
And Levon, let me interject real quickly, because on that point, I think it's worthwhile for our viewers to actually hear the language. And it says, unanimously, the court ruled that Azerbaijan must take all necessary measures to prevent the incitement and promotion of racial hatred and discrimination. And here's the key phrase, including by its officials and public institutions targeted at persons of Armenian national or ethnic origin. Yegishev, would you mind commenting about the evidence that was presented to the court regarding racial hatred and discrimination, and what led to the language that we're seeing there, including by its officials and public institutions?
Sure. Thank you. First, I think it is a very key point that we're discussing now. But before turning to that point, I want just to make one important comment with regards connected with that. It is the court's finding of the rights with regard to the rights protected by different by the convention and what was new in this case. I can read out the paragraph 81 of the order, which is important to in this respect. If you read the first paragraph, well, it says that the court recalls that in the past cases in which cert was at issue, it stated that the rights stipulated in Article 5A, B, C, D, and E are of such nature that prejudice to them is capable of causing irreparable harm. This is the actually citation to other cases. That's the Georgia, Russia, and then Ukraine, Russia, and Qatar, UAE cases. But what the court says in this order, which is new, the court considers that statements, this statement also holds true in respect of the right of persons not to be subject to racial hatred and discrimination that stems from Article 4 of the CERT. This is new for the Armenian case, and I think it's very important to highlight this, which is the article which prohibits actually the subjecting persons of racial hatred and discrimination by, and the court goes on, and the court in one paragraph down, it specifically says that, I can read out again the language, then we can discuss this, that what actually Article 4 prohibits the racial anti like Armenian propaganda or racial propaganda and promoting racial hatred and incitement to racial discrimination. And the court says that this holds particularly true when rhetoric espousing racial discrimination is employed by high-ranking officials of the state. And what the court is saying, the court is actually saying that when high-ranking officials of a state, by the way, the court actually is emphasizing the word high-ranking officials here. It is important to emphasize that too. What the court is saying that when high-ranking officials engage in such hate propaganda, that creates an atmosphere in which a bodily injury or a psychological harm to be caused to Armenian captives or victims there is highly risky. It's becoming very probable, and that's the I think core of this case here, because what the court is saying, the court is based on the evidentiary materials that was presented to the court by the Armenian Council's team. As you may remember from the hearings, I think it was an array of evidentiary materials presented by the Council team, like citations and promoting the anti-Armenian sentiments and anti-Armenian propaganda on all levels, starting from the most high-ranking level, going down to the ladder, and then going to the to lower levels, and to which was creating this propensity and this animosity towards ethnic Armenians, and which is the root cause of the war and aggression. That's what I see here, and I think why this is important. But I think that's very simple. That's because this case, and particularly this finding and this comment by in the court's order, is so important. And again, this is just the beginning of the case. We should bear this in mind, and this is just an order on provisional measures. And we'll still have a long journey ahead of us. And of course, Armenia isn't very seriously approaching to this case. Armenia has seriously approached to this case. And Armenia is seriously raising and protecting its rights under the Convention on International Law, and will pursue that in the future. And we believe, as we actually made the statement during the hearings, this is a very important precondition for securing peace in the region. This is highly crucial here. And we should keep this in mind when also discussing the case. I think abiding by the commitment under the CERT for Azerbaijan is a very crucial milestone or cornerstone for securing peace. I think there is no other way seriously, there's no other way. And while Azerbaijan is trying to mirror the case to create some impression by bringing a mirror case, this is a tactic we know, we understand, but that's not genuine. What is genuine is that they should start taking their commitments seriously under the concert.
I have a question, if you don't mind. Since you talked about securing peace in the region, Levon, you wrote something a few days back, which I really took a liking to. You said, and it goes into what Yerisha was talking about, securing peace in the region. And here's something you said. The Republic of Armenia could take a political step and declare at the highest level that it is ready to submit its territorial disputes and border issues with Azerbaijan to any international arbitration tribunal or the United Nations International Court of Justice. And you followed it up by saying the consequences of that can be twofold. Scenario one, the Azeri side rejects, and the Armenian side, of course, receives obvious political dividends from the fact that the international community already understands that one side is open, willing, and more confident in its position and in defending it in its interests than the other side. And it will obviously shut the mouths of people who constantly talk about the whole territory of Armenia being Azerbaijani, because it will show that along with making these allegations, people refuse to take the case to an international court. And finally, scenario two, you opined that Azerbaijan agrees to go to an international tribunal, which you then said that this is clearly the least likely option, but it's also the best option for us. In other words, this type of a statement of willingness, of readiness by Armenia, in and of itself is a win-win option in any case. So my question to you, with that in the backdrop, is this. It's the obvious question. Why then the Armenian government is not taking this step? I don't know if I should put Yerisha on the spot as counsel for the Republic, but I'm putting you on the spot because you made those remarks that resonated with me. Did I misunderstand your remarks?
No, let me first of all clarify the remarks
Sure.
So that they make more sense. Well, first things off, I mean, it's more than obvious that the Republic of Armenia is now operating under extreme duress and under obvious threat of force.
Yes.
And sometimes under obvious use of force from the outside. And of course, in my opinion, and I believe many lawyers would agree, the situation really would pretty much question the outcomes of any political decisions that are happening in such circumstances and under such duress and pressure. The second thing, and this is more of a legal formality for listeners to understand, is that you cannot take any dispute to an international court or to an international arbitration at a given moment when you so decide. So the consent of the parties, both of the parties to a dispute, is very important. So one of the reasons why Armenia was able to take the issue pertaining to racial discrimination to the International Court of Justice is because there is a convention to which both parties, both Armenia and Azerbaijan are parties to, and which provides for the modality of bringing such disputes to the International Court of Justice under Article 22. There is no such international instrument to which both Armenia and Azerbaijan would be parties to, which would allow Armenia to bring territorial issues, territorial disputes against its neighbor before any international institution. For that to happen, the consent of Azerbaijan is also required. So therefore, hence the suggestion. And the suggestion still stands, but it of course depends on many intricacies and also political aspects of which you and I may not be aware of. But still, I think it's something that I would very much urge political decision makers to look into, and probably that is something that probably at later stage could be a useful tool in the hands of the Republic of Armenia.
Yeah, if I may, Garo, these are points of great contention. We've seen them flaring up throughout in the aftermath of the war. Clearly, one issue that has been long-standing, if you will, and it has its roots perhaps in the Armenian history in this particular region of the world. And that relates to cultural heritage. And I want to talk a little bit about that because the court says some really important things about cultural heritage, not the least of which is its reminder prior to making its order to Azerbaijan, and no spoiler alert here, it orders Azerbaijan to ensure that there's no destruction of Armenian cultural heritage, and we'll talk about that in a little bit more detail in a second. But as a precursor to that, it reminds the parties that the orders on provisional measures have binding effect on the states, and that creates international obligations for any party to whom the provisional measures are addressed. And so the reason I bring that up in terms of cultural heritage is that this is an issue that we saw throughout the war. We've seen it before the war. Obviously, the Julfa Cemetery in Nakhichevan played predominantly in terms of some of the narrative and the application. But we know of a long-standing pattern of conduct with respect to the erasure and the destruction of Armenian cultural heritage. And my question is, how does the case tie cultural heritage destruction to racial discrimination? This is a really important theme, and perhaps maybe Yerisha, you could hit this first, and then I want to ask Levon kind of a follow-up with respect to this as well.
Sure. Thank you. Thank you, Karnik, for the question. This is a very important aspect of the case, a very crucial aspect, I would say. How does it tie with it? I think it's very simple, and what Azerbaijan has been pursuing for decades. And it is the tendency and the purpose of eliminating any and every trace of Armenian existence in the region. That includes, of course, first of all, Armenian cultural and religious sites and heritage in different parts of the region, including in Artsakh and Nakhichevan, in different parts where it had control over time, or it has control now currently. And unfortunately, what we see that it's a continuous policy of either destruction of such sites, which was the case of Juha Cemetery, or it's either the alteration, or it can be also falsifying the history by presenting those sites or cultural heritage as belonging to other groups, Albanian, for example. And that's the trace of the policy which we have been witnessing, unfortunately, by Azerbaijan. And that's a very integral part of racial animosity and hatred, which is connected, which is by denying the existence of Armenians, by erasing that Armenians have been here, and provided that and creating impression that no Armenians was there, and I think only Azerbaijan is there, which is completely falsifying the history. It's completely denying, actually, and not being able to face the history or to face the facts. And that's a part of also so-called cultural genocide, I would say, which is a very important aspect of the case, and I hope, and we are looking forward to this part, and we have an array of evidence relating to the preservation of the cultural heritage sites and religious sites and monuments, the vandalization of monuments, which we have accumulated, are continuing to accumulate, and to be presenting to the court, of course. And we have already presented an array of evidence in regard to that, and we will continue to present more evidence to the court, of course, on this respect. And this is just the beginning, and we are convinced that this part, I mean, the preservation of Armenian cultural heritage is the necessary precondition also, or it can be a consequence of seizing the hate policies or hate animosity towards Armenians. That's because the destruction or alteration of the Armenian cultural heritage is very near or very immediate effect or immediate consequence of the created anti-Armenian atmosphere. And when you nurture this anti-Armenian sentiments for decades, and of course, inevitably you go to denying the Armenian existence anywhere and everywhere. Like that's very simple. And I think those two pillars, I mean, the anti-Armenian propaganda and hate speech and destruction of cultural heritage or falsifying or altering cultural heritage are like integrally connected with each other. It's one causing the other. And yeah, that's a cornerstone. I think, and we're looking for it, I think, in that case. Thanks.
Yeah, and yes, sorry, Levon, if you wouldn't mind commenting about, it's pretty powerful language that's coming from the court with respect to preventing and punishing acts of vandalism and desecration. And it specifies not only churches, but monuments, landmarks, cemeteries, artifacts. Can you tell us a little bit about what you see in terms of the force of that? As I read before, that this is a binding international legal obligation. What does that mean? We've had a lot of people, a lot of cultural heritage activists on our program throughout the course of the war, identifying, cataloging, and disseminating information regarding what was happening to Armenian cultural heritage and what is still happening under. How does this play going forward from December 7th? Maybe that's the question I'm really trying to get at.
A little bit of introduction prior to coming to your question directly. Well, the first time, probably the first time that the International Court of Justice basically hinted that human rights instruments can be used as tools for the protection of cultural heritage was in 2007, when in Bosnia-Herzegovina versus Serbia case, the International Court of Justice basically recognized that destruction of cultural heritage can be clear evidence of the specific genocidal intent. So based on that convention, of course, there has been a lot of talks within the Armenian scholarly community that we should do something also about the Juga Cemetery. And unfortunately, of course, this war brought a whole new host of new issues with it, because now the destruction is much more widespread, and there are new cultural artifacts of cultural heritage that are under threat. And of course, the first thing, and this is probably important for the listeners to know, the first attempt was made by you and I before the European Court of Human Rights as representatives of the Armenian Apostolic Church to apply an interim measure before the European Court of Human Rights, which unfortunately did not work. And this finally, thank to God, this is finally an order by an international judicial institution which recognizes and protects that cultural heritage, and also acknowledges clearly that the protection falls within the scopes of the Convention on the Elimination of Racial Discrimination. And this is much broader, because in Armenian Apostolic Church versus Azerbaijan case, we only raise the protection of cultural heritage, the issue of protection of cultural heritage, which is Christian and directly linked to the Armenian Church. Under the ICJ ruling, we have a much broader scope. This is pretty much covering any cultural heritage artifacts that is linked to Armenia. And we know there are the ruins of Tigranakert there in Akna, left under the Azerbaijani control. Some of those ruins cannot be, pretty much are pre-Christian as such, and therefore would not fall under the protection if it were to relate to only Christian heritage. And therefore we have an order which is much broader and provides for an opportunity to ensure this protection for the Armenian, let's say, background and the footprint in the region, which at the end of the day may have much more important ramifications and consequences. Of course, the right of the individuals to visit those monuments has not been granted by the ICJ ruling, because the ICJ decided that there is no expediency in the request, but it's still within the scopes of the application. And the final application and the final judgment definitely will have to touch on the issue of the Armenian communities to have the right to visit their places of worship, cemeteries, etc. And how this is going to play out, of course, will also largely depend on how the Republic of Armenia will manage to utilize these rulings, and of course, the final judgment when it comes to it, for the benefit, for its own benefit. But these are the let's say the grounds for future changes, and I believe this judicial proceeding and the order, of course, as part of it, are going to be tools for changing the status quo for the benefit of Armenians and Armenians in general.
Let me sway it just slightly. A member of our audience writes, does Russia recognize this court and any outcomes that come from them? I was going to ask, keep that in the background if you would for a second. I was going to ask, what do you make of the court's ruling, which I think was December 7th, and then the Ombudsman of the Republic, Arman Tatoyan, who we all know very well, issued a statement and said the following sentence, actually, which I agree with. The Azerbaijani authorities are responsible for the killing and the depriving of the life of a serviceman of the Armenian Armed Forces and inflicting gunshot injuries on several others on December 10, 2021. On December 10, 2021. Is that any different than Azerbaijan basically disregarding the ICJ decision? And with that in mind, and all these incursions into what I consider to be Armenia, regardless of what people may try and spin it to be, should the Republic of Armenia once and for all say, you know what, we don't recognize this business of Soviet interstate borders between Soviet states that existed in the Soviet era, and enough with this, because this Soviet border business seems, I think you would agree with me, is nothing more than political cover to accomplish that which earlier you said something very telling, Levon. There are many things that you and I do not know of. Yes, I agree. There are many things you and I do not know of. But we are living in very dangerous times. On one end, you folks go into The Hague and bring back substantive accomplishment. And then 3 days later, that accomplishment and the meaning of the court opinion is disregarded by the very party that the meaning was intended intended that the party abide by, Azerbaijan. What's wrong with this picture?
Yeah. Well, first thing probably to mention is that any violations that happened post the order of the International Court of Justice, those violations are definitely going to be brought to the attention of the court. And no denying that, I'm pretty sure that the court is going to make its finding with those respects. Mm-hmm. With respect to the Soviet borders, I mean, and I'm going to talk in my private capacity only.
Yes.
I wrote on this extensively. My PhD thesis at Yerevan State University was about non-applicability of the Soviet borders with respect to for the determination of title to territory in Armenia-Azerbaijan relations. And I think the international law is pretty clear on this. The way that international law and international obligations are created is very specific. They are created by the practice of the states involved in specific relations, and the only situations where the so-called continuation of the administrative borders has been accepted, those are situations of decolonization in Latin America and Africa. And in both those situations, the Soviet border, the administrative borders were adopted based on the consent of all parties involved. And of course, there is no way under international law to kind of bring the practice of other regions in other international and historical contexts and to kind of claim that that practice of Latin American states has now become binding somehow for the Republic of Armenia and the Republic of Azerbaijan, and they're bound by the Soviet borders. But it's a completely different story. And I do hope that at a certain stage, the Republic of Armenia will have the capacity, the political capacity to raise this issue. We already have seen some good signals. For example, during one of the recent speeches of the Prime Minister, I've heard that now we're at least questioning the issue of enclaves, that Azerbaijan otherwise claims to be its own territory, and it's a starting point. I think if we start with the enclaves, there is a way to go. There is a way to go, and I think the idea has to come not only from within the government, but also within from within the society. There has to be a, let's say, public demand for that, I think. And I think we'll very slowly, of course, but we're moving in that direction. And of course, there's one more important thing to emphasize. Of course, there has been some acknowledgement of the Soviet borders in public discourse by the public officials. But again, we need to understand the context in which those claims were made. We have border incidents on a daily basis. We have an encroaching threat by the Azerbaijani forces on a daily basis. We have captives within Azerbaijan. So I think this is the general, given the fact that this is the general environment and the general context in which these statements are being made, I don't think that they've become binding and have legal significance under public international law. So we'll see how it goes.
Yerisha, if you don't mind, in your official or unofficial capacity, perhaps in your official capacity, what are your views about the most serious and strategic problems which are facing the Republic of Armenia in the short term and in the long term? Are there any such concerns and steps taken to address those concerns on the legal front?
I think I can only comment within limits of my capacity, because I'm bound my capacity.
You cut out. Was it individual capacity?
No. I cannot comment on any individual capacity at this point, because I am official. Yeah, because I'm bound by my official capacity, so I cannot go outside those boundaries, unfortunately. Although I may or may not share some of the views expressed, of course. But of course, in my official capacity, what I wanted to comment, first of all, before turning to the question that you asked, Carl, is regarding the issue of the cultural heritage that we're discussing. I just will quickly comment on that and go to the other questions that you were discussing with Levon also. And I think it is important also to note here that we were talking about the access, for example, of ethnic Armenians to cultural heritage sites or religious sites. which was not actually granted as a measure by the court, as a provisional measure, because the court didn't find that there is an urgency. But it's important to highlight here that the court found that those rights are plausible under the convention, and there is a link between the measure requested and the rights guaranteed under the convention. This is very important. And the court specifically touches on this issue, and I think it's an important milestone with regard to this part of the case. That's first with regard to the case. Second, with regard to the measures requested and the order of the court and the aftermath of the order and the observance of the order by Azerbaijan. Of course, we're not naive. We're not like romantics. We think that the order comes out on the 7th, and on the 8th, Azerbaijan starts to strictly behave in line with its all obligations. We know that this is not going to happen. We understand that this is not going to happen. Why? Because it's very simple. Because it's very hard to change the behavior of the country, which has been propelling this hatred and animosity towards one ethnic group. And it's heightened to the level of the state policy, to the highest level. And it's really hard to change the behavior of that country, of course. Although it is also important to highlight that, having said that, when we were presenting the case at a court in The Hague, and during the provisional measures hearing, we noticed behavioral change in the country. I think that's the legal proceedings had already started impacting Azerbaijan's behavior, which was connected with its, very, let's say, desperate moves, I would say, in regard to removing the mannequins and helmets, which were exhibited in the military trophies park right before the hearings, and announcing that by their agent and making some undertakings that those mannequins and helmets were removed permanently, which means that they will not be exhibited again. And notes also that this was expressly noted by the court itself in its order in the concluding paragraphs, where the court is speaking about the hate speech and propaganda, and also with regard to military trophies park, the court is very expressly stating that it observes of the statement made by the agent of Azerbaijan about the removal of the helmets and mannequins, and the permanent removal of the helmets and mannequins, that they're not going to exhibit those articles again. And this is very important milestone too. And why am I pointing out this little details? Not little, I think it's important details, like each of them. Just to exhibit what impact legal proceedings can have on countries' behavior. And it is also important to also bear in mind that Armenia has never actively engaged with using the legal tools until recently. This is 2021 is the year where Armenia, first time in the history ever, initiated international legal proceedings. First time history ever. We didn't do it back, for example, in the 90s, or we didn't do it during 2016 for the April War. We just did it on 2021. We started actively engaging with international legal tools now. And it's also important to be a little bit patient. It is important to be a little bit, not to be short-sighted, because we cannot demand everything at once. It doesn't happen that way. It never happens that way. And we have to be very patient. We have to be very consistent, and we have to be in our position, in our steps, and in engaging. And I'm a very amateur believer in that, because I'm as an international I'm an international lawyer, and I believe, and I truly believe that international legal tools, although they lack some, they lack this apparatus of enforcement, or the effective apparatus of enforcement, as opposed to internal judicial acts or judicial decisions. But still, those are making impact and can make even more impact if you use them correctly, if you approach them correctly. And this is very important, and Armenia should, and also it is important from the terms, or from the point of view of the sovereignty of the country. Because when you are making such a move in international legal arena, when you're making such moves, you're reclaiming, or you're like emphasizing your sovereign rights, sovereignty, that you're a state, you're an independent country, sovereign country, which is a part of international community, which is abiding by the rules of international community, which wants to play by the rules set by international communities. It's a full member of international community, abiding by international law. This is a very bold message. And I think for Armenia, it is highly important at this juncture to make this message even more clear. Because the other party, Azerbaijan, I think it is an example of a country which is consistently behaving outside the scope and trying to portray as if they are abiding. But this is we know all that this is very false. This is false. They're trying to falsify that too. But still, I think Armenia should be very consistent in this. We should follow the orders, should follow the actions of Azerbaijan in this respect in the light of the orders. And of course, Armenia will be presenting any evidence about Azerbaijan's behavior, if that's going be like against the orders, or is violating, or is exacerbating the disputes between the countries. Yeah, thank you. Just those my comments.
Yeah, thank you for that. And I have to say, right, you've hit a lot of the key points with respect to the exercise of sovereignty and the way that, frankly, truth has a way of percolating to the top in the judicial proceeding, which might take a long time. But the ramifications, once points of law are established, are awfully long-standing. I have to say also that rights are not self-executing. Because they're written in a convention doesn't mean that you get to enjoy them in situations where they are breached, unless you exercise the procedural mechanisms that are available to you in order to claim those rights and secure statements and orders that identify breaches of those rights. And I have found that even, and I think I'm really happy that you've kind of contextualized this case to be not necessarily a product of the war, but one that bridges really a longer time span and issues that kind of transcend the immediate political, geopolitical situation. And they really do. They touch and they will touch on more and more issues going forward. And I think the value of this case cannot be understated. And I commend the both of you really for architectural work that it takes to bring this case. It would be, we cannot ignore and need to acknowledge also the team of counsel, I have to say, at Foley, brilliantly led by Dr. Salonidis, as well as lawyers Larry Martin, Sean Murphy, Robert Kolb, and Pierre Dargent, who really, as the pleaders, to those of you who watched the proceedings, saw the sheer strength of the presentations, especially in a comparative sense, I have to say. And the team of lawyers, obviously, at the Armenian delegation within the Republic of Armenia, as well as the team of lawyers that supported the legal counsel as well. It was a tremendous proceeding in a lot of different ways. And I think that those of you who had the privilege to read the orders and the applications will see just how valuable it's been. And I want to ask Levon Yerishe, we have just a couple minutes left, and I wanted to ask you guys just for some closing thoughts, big picture items that you think are important for the public to take away from the impact of this case. And really, I have to say, and again, it's fallen on the two of your shoulders and the people that support you, the real successes we've had in the international legal realm. Not only with this case, I have to say this is appears to be at this stage the culmination, the apex of what's been building throughout the, well, frankly, pre-war and throughout the war and in the aftermath of the war. There's been a lot of, this has been a front that Armenia has shown resilience and strength at almost every turn, and results. So if I'll stop there and ask Levon and Yerishe, perhaps in that order, to offer just some closing remarks on your view of the impact of the case going forward, and what you'd like the people watching to take away from this.
Yeah, I'll start from seconding the idea that this is definitely an act of sovereignty. And the viewers have to keep in mind that this is not the only proceeding, international interstate proceeding that is happening right now. Yerishe Kyriakosan is also leading 2 cases against Azerbaijan and Turkey before the European Court of Human Rights, which is not less important. And as I said previously, I believe these international proceedings, and I still have a hope that these are not the only judicial proceedings that Armenia files, are going to become a game changer. I would call on the Armenians worldwide, both within Armenia and in diaspora, to be cognizant of these proceedings and to support those. It's really not the best thing to see that the outcomes of the provisional orders are misinterpreted within the Armenian society based on the probably influenced by the wave of pro-Azerbaijani propaganda that comes from the East, and sometimes also that the provisional measures are somehow misrepresented for internal political games. That's really disgusting. This is not something that needs to happen, and I do believe that these proceedings are something we do hope, at least I do hope, that these proceedings are something that have the capacity to unite Armenians worldwide around it, because these are the claims of Armenians against foreign threats, and these are initiatives that are supposed to unite the people and not to split. So yeah, I'll probably stop here and give the privilege of ending the conversation to Yerishe Kyriakosan. Thank you.
Thank you. Thank you, Levon. Thank you, Karnik. Indeed, this is, I can't say much, of course. Actually, I have already said some concluding thoughts in my previous comment. And of course, this proceeding is a very important proceeding for the country. And I think the order that the country received already by the ICJ, I think it's a win for us. And we should understand, and I've been saying this quite often now, but I think it's not enough to say, though, I think I can say it every time, that we need to be very attentive to the details. We need to be very mindful about the significance of the order. We need to be very mindful of what it says, about this milestone. By saying we, I'm referring not only to, for example, to the diplomatic representative of the country, but also to the public and the members of the public, professional communities. Goes like transforming it, or like spreading the message and understanding first of all understanding the message, first of all understanding the value of the orders, the order actually, and translating the value and the messages to the community correctly, and also taking the right action based on that order, because we need to be to carry this through. And of course, being very mindful. And I also wanted to thank Karnik for the notes to the council's team. And of course, that's very important to mention the Foley Hawks council team, led by Mr. Salvundis and Larry Martin, and the also brilliant experts, brilliant advisors. The team that we had involved, Professor Murphy, Professor Kolb, the Professor Darjan, and of course the Armenian team, the Armenian delegation team, which supported with legal experts, and would have done a tremendous work. I think it was every one of you. I think Carnegie was also involved. Of course, not mentioning Levon, we all know, and Sheila, Bailan, the team at the Agent's Office of Armenia, which has done a tremendous work and is continuing to do tremendous work. So thanks a lot, and I think we should be very persistent at this point, and we should be active and in pursuing the rights of the Republic further. Thanks a lot.
Thank you to both of you. And Levon, you were incorrect in one thing, that the final words are going to go to Yerishe, because we have grown accustomed to giving the final word to Garo to close out our discussions. And I just want to thank you for taking the time both of you, to dig into the case with us, into the order and the ramifications and the importance of the case. And as one of our commenters messaged during the proceedings, that this is a real strong message of unity. And I think, Yerishe, you hit that point, that nail right on the head with your comments, that this is something that we as a nation should and could and should unify around at all levels. And we have moved forward in a really powerful manner, and the first step has been a very successful one. And over the course of this case, the support and the interest of the Armenian community is going to be invaluable. And with that, I want to send it to Garo for your final remarks.
Thank you, Carnegie. I want to thank also, I also want to thank Yerishe, Levon, you, Carnegie, and the entire team that Yerishe marched into The Hague with and delivered what I value to be extremely important milestone, as we all have said it in our own way, an exercise of sovereignty. And I look forward to the next lawsuit, the next application, petition, which will have a title of Armenia versus Republic of Turkey, in terms of the jihadists that were brought over and wreaked havoc on Armenian people. And not only just in Artsakh, but also, we all know during the 44-day war that there were drones and bombs that landed on sovereign Armenia territory, Republic of Armenia territory. In talking about unity, we would be remiss if we did not talk about the elephant that's roaming the Armenian globe. And that is all this talk about restoration of relations, if you will, between Armenia and Republic of Turkey. And this appointed representatives for normalization of relations, from Çavuşoğlu to I believe it's Mr. Babikyan from the Republic of Armenia, and what lies ahead. So here comes my closing remarks. Armenia was defeated in a battle against the enemy in late 2020, the 44-day war that we have come to refer to it. We must be sure that the defeat of the battle does not lead us to defeat in a bigger and general war, all in the name of restoration of relations between Armenia and Turkey, which can only happen if the interests of the nation are trampled under our own feet. We have an obligation, folks. And in this sense, and immediately, the Armenian authorities must understand, they really must understand, that the complex wrinkle of talks or relations with Turkey is a subject on which no wall of silence can be erected between Armenia and diaspora, in Armenia, among different Armenian political parties or otherwise, and about which this so-called divisiveness and the wall that exists, the Armenian people in Armenia and around the world should be considered. and considered very quickly, taking into account the scope of the question and the seriousness of the moment. The Armenian authorities have an obligation to disclose their approach to all of us very quickly, to the extent that approach affects all of us, and in every extent that approach affects all of us, wherever we may reside. Particularly, obviously, the Armenians of Artsakh, the Armenians of Armenia, but also the Armenians outside the borders of Armenia. It is the duty of the Armenian authorities to enter into talks with various segments of the Armenian nation, especially with the diaspora, even if such talks sometimes lead to difficult or uneasy situations. Because when it comes to the Republic of Turkey, the Armenian global national front cannot remain fragile, especially in the current climate of uncertainty and pressing priorities, and especially when the enemy finds in confusion and in uncertainty opportunities to strike us again and again. And in this regard, neither delay nor gamesmanship of opposing political factions or even another mistake by the ruling party can lead us to a good place. And here, the responsibility for any errors or omissions can no longer be attributed to the enemy. Thank you all. Good night and good day.